Okay, what in your view would need to change? There's a lot of people that are raising certain issues about the conflict of interest. So for the sake of our viewers who are watching in East Africa, the Judicial Service Commission had a subcommittee to take a look at these allegations against a Supreme Court justice. But then they're going to be presenting that to the full JSC, that's the Judicial Service Commission, tomorrow. And some members of that Judicial Service Commission, the Chief Justice, Willie Mutunga, also Justice Smokin Wanjala, sat in that case that heard Evans Kidero's petition. And some point that to a very obvious conflict of interest. So my question to you is, are there any mistakes or misjudgments or things that we did not foresee in 2010 that perhaps this provides a good opportunity to start to interrogate and see how to change?
Let me answer your question, Yvonne, by saying that the Supreme Court itself has come up with what they call the doctrine of necessity, saying that because there are only 7 judges and a minimum of 5 must sit in Kenya for any decision, the standard that must be applied to them in questions of disqualification and questions of bias have to be different from the standards that apply to the lower court. I would say that the Judicial Service Commission is also able to apply the doctrine of necessity. But very importantly, the structure of the Constitution is that it is not the Judicial Service Commission that should substantively investigate the allegations. In fact, its job is very limited. It is to establish whether the basic case has been laid, that is not just frivolous, that is substantial, to be submitted to a tribunal that will be formed by the president. If indeed the Judicial Service Commission sees this, then the tribunal will be constituted by the president upon the report of the Judicial Service Commission, and for sure that is our hope, that this tribunal will be independent, will not have the conflicts of interest. So I wouldn't want, in summary, Yvonne, to say let's start amending or changing the structure of the judiciary or the Judicial Service Commission. The test has not yet taken place. It is actually in the process of taking place. It's like we are examiners and the student is sitting the exam. Let us not already start thinking how we will fail the student or change the examination before we see whether the student will pass the exam. Right now, I think there is all to look forward to. There is all to test. We are not yet sure one way or the other. Let's keep watching.
All right, a great analogy. In conclusion, because a lot of people, look to Kenya. We're trying to make some great strides in democracy, in justice, in human rights. Do you think this in any way affects Kenya's standing within the region? Lots of people looking to Kenya for best practice. And like you say, we're not judging this process yet. But, how do you think this would affect, whichever way this goes, Kenya's standing in the region and the continent?
I think definitely it's a sad day when you have such serious allegations against a judge who is senior in the court structure from the highest court in the land, and it could deal a blow to Kenya's reputation or prestige in the region or in the continent. But again, I insist, Yvonne, I think what people want to see is whether we are able to have a credible process that will result in a stronger judiciary. And if indeed we are able to do so, it may actually result in the opposite outcome, which is that Kenya's reputation and credibility will have increased rather than decreased. We know that in various other countries in the continent, there have been similar investigations against top judges from West Africa, even from here in East Africa, as well as South Africa. There were questions recently about 1 or 2 of the candidates for the Chief Justice position. I think what people in the continent want to see is, can you manage the process transparently, professionally, credibly, avoid conflicts of interest, and come out with an outcome that is just, that is fair, and that will strengthen the judiciary. There's all to play for.
All right, okay, thank you very much for your perspective, Charles Kanjama, who is a lawyer, joining us from our City Centre studios here in Nairobi, Kenya. Charles, we thank you for your time this evening. We want to move to other stories now. The efforts by Kenya to withdraw from the International Criminal Court may have gotten a boost on Sunday after the African Union adopted a proposal by President Uhuru Kenyatta to develop a roadmap for mass withdrawal by African nations from the Rome Statute, the treaty that established the ICC. The adoption is the latest move after the AU toyed with several options, from deferral of cases to seeking immunity for sitting heads of state. But what exactly will it take to exit from the ICC? Rita Tinina sought expert view.
It's an honor to welcome you to this 26th session.
Sunday's move by the African Union to adopt a proposal by Kenyan President Uhuru Kenyatta to develop a roadmap for withdrawal from the Rome Statute is only the latest in efforts to cut ties with the International Criminal Court, which Kenya has been spearheading. Kenya has the attention and support of Big Brother, the AU, but with the 34 African countries having ratified the Rome Statute individually, every country will have to go through the ropes alone.
Certainly, it's not a collective process. A resolution by the AU does not necessarily mean an automatic withdrawal. Each country would have to withdraw from the Rome Statute. So really, the decision boils down to each individual country.
Countries are allowed to withdraw from the Rome Statute. According to Article 127 of the statute, a state party may, by written notification addressed to the Secretary General of the United Nations, withdraw from the statute. The withdrawal shall take effect 1 year after the date of receipt of the notification. For Kenya, several dynamics are at play.
The challenge we have is that our constitution is very clear that any treaty or any convention that we accede or we ratify becomes part of our law. So until we actually withdraw from those instruments and make sure that it's not part of those treaties that we have signed to, these treaties will continue to bind us.
All rise, veuillez-vous-lever.
For Kenya to withdraw, it will have to repeal the International Crimes Act, which incorporates the Rome Statute into Kenyan law and obligates the government to cooperate with the ICC. On that front, Kenya has already taken some steps. In 2013, the Kenyan Parliament, in an emergency motion, approved Kenya's exit from the ICC. And last year, the Justice and Legal Affairs Committee approved the publication of a bill by Bumula MP Boniface Otsula seeking to repeal the International Crimes Act 2008 in its entirety.
And once Parliament adopts that by majority and it goes on record, that law stands repealed, which will require the president to sign and repeal that law. Our case is a bit unique. It's not enough to repeal the law, because even if you repeal it and you have not withdrawn from it, the constitution binds us on it.
Kenya has of late turned its attention to the AU, perhaps seeking to be in good company in the withdrawal quest. But even if countries were to withdraw, that will be no cushion against indictment by the ICC.
Crimes against humanity, such as mass murder, genocide and so on, remain crimes. Whether you are part of the ICC or not, once any member of the United Nations, through convincing the UN Security Council, moves a motion, then one country or one leader becomes culpable.
Such is the case with Sudan, which is not a signatory to the Rome Statute, but whose president Omar al-Bashir has been indicted over genocide, war crimes and crimes against humanity following the Darfur conflict.
Whether in the course of retiring and reflecting on
withdrawal from the Rome Statute will not affect ongoing cases. Kenya's Deputy President William Ruto is facing crimes against humanity charges before the Hague-based court, and experts argue the timing of the withdrawal quest does not augur well for Kenya.
But when we are trying to withdraw, when we are before the court, it means that we are simply running away from the arms of justice.
Of the 123 nations that have ratified the Rome Statute, Africa having the most representation with 34 state parties, no country has withdrawn from the statute. And Kenya, which has been spearheading the campaign against the ICC, would go into history books, if at all. Rita Tinina, KTN News.